take care of your privacy and everything else. Conveyancing is one of the most important units in your life as a person, and I usually call it, this is the unit of men. You know, when we talk about land, this is a very serious one. Now, for those men that are having TikToks, an old man of close to 30 years, you're on TikTok, you're on Snapchat, and your age mates are looking for land. Are you okay? So if you're a man and you have a TikTok app on your phone and a Snapchat, you need to ask yourself a lot of questions. You need of Jesus Christ, whichever. Now, conveyancing is the law of the land. Okay, so let's start with conveyancing and see what is it about conveyancing. Conveyancing, again, is the most feared unit in KSL. I don't know why they fear it. And conveyancing was one of the most failed units in KSL again. It's been for quite some time. It's competing with criminal, but conveyancing is very easy. Now, conveyancing falls in the same category as civil and criminal and probate. Why? Because it is a process. Okay. Now, for those who went to Alliance like myself, you are told that when something ends with an ing, it is a procedure, it is a process. Okay, so conveyancing, it's a process. Now, in understanding conveyancing, you need to understand that conveyancing is the law of the land. Okay, now what is it about conveyancing that is making it so much feared and complicated? Let's unpack it. The first thing, it is very wide. Okay, the next thing, it is too detailed, and then it is procedural. And what makes it easier is that it is a procedure. Okay, now let's start with what conveyancing is and what you know about conveyancing. Are you together? So the first thing, conveyancing is a process of conveying something. So there are three words you need to understand. The first word is what we are calling a conveyance. Okay, what is a conveyance? Number two, you need to understand the person you're calling a conveyancer. And then number three, you need to understand the person you're calling, what the thing you're calling conveyancing. Okay, now conveyancing is the process of transferring an interest in land. That is conveyancing. You are conveying an interest in land. So when you are conveying, to convey is to transmit, is to transfer. Okay, when I'm conveying an information, I'm transferring that information from myself to you or to my audience. Okay, when I'm conveying a document, I'm taking the document where it is and I'm taking it to the person that needs to have it. So that is the what we call conveyancing, the process of transferring an interest in land. Are you together? That is the first thing you need to understand. Now, the next thing you need to understand is a conveyance. Now, a conveyance is a document that transfers that interest. Now, an interest is conveyed through a document. An interest is conveyed through a document. Are you together? Now, that document is what we call a conveyance. And then a conveyancer is now the person that practices conveyancing. The advocate or the estate agent or any person that practices conveyancing is called the conveyancer. So that is what you need to understand. So mark it there. Let's come back. Let's go back to campus. Now, for those of you who went to serious campuses like myself, you are taught the principles of land law. Okay, you went through land laws and you are taught what is land and everything else. Okay, you are taught the principles covering land. Are we together? The principles covering land. So we talk about the fixtures principle, the one I just mentioned, that anything that is fixed to the land forms part of the land and moves with the land. Okay. Number two, you remember the Kujus maxim that says that if you own a piece of land, you own it all the way to the skies and deep down to the stratosphere. Okay, the stratosphere is part of Earth. I know some of you did CRA. When serious students in high school were doing serious topics and units, you're doing CRA. So if you own land, you're owning it to the very ends of the sky and deep down. Okay, so that is what you're calling. That is what you're calling. Those are some of the principles that you know in land. What is land? Now, land is the bare surface and anything that is fixed on land. So the degree of fixation also matters. Okay, how do you determine when something is fixed? If you can move it without destroying the physical composition of that specific object, then that is not a fixture. For instance, a building, you cannot move a building from this place to the other. Okay, that is what you call. The degree of fixation. So anything that is fixed on land is forming part of land. So land includes a building. So when you talk about conveyancing, we are talking about conveying an interest in land together with an interest on a building that is on top of the land. It's a very simple concept, my friends. Conveyancing is the least thing that should worry you, okay? But most importantly, you need to understand that conveyancing is a process. Guys, the principles of land laws were taught in your campus. They are not taught anywhere in the Kenya School of Law. They're not taught anywhere, but you need to know it at the back of your mind. Nobody cares about the principles of land law in KSL. What we care about is conveyancing, which is the process of conveying an interest in land. So you've understood the concept of land. Number two, you need to understand the importance of land. Okay, the importance of land. Now, that is a common and obvious question that, shamba si ni shamba, nini. You need to understand, why do we have land? What is the importance of land? It's a basic question that anybody can answer. Okay, that is also something you need to understand. The next thing you need to understand are the interest in land. Now, the blanket statement that you need to appreciate is that nobody owns land. Okay, nobody owns land. What do I mean? Nobody can walk with land in their pockets. Nobody can walk and say, this is my land, I'm going to put it in my bag and I'll walk with it. Nobody can own land. Okay, what you have on that land is just an interest on that land. Okay, the nature of interest you have on the land determines how long you'll have the land. Okay, so that is why we are saying that conveyancing is the process of conveying, not conveying land, but conveying an interest in land, because you can't convey land. You can't transfer land. You can't say, hey, take this land and go with it, or bring me that land. No, you can't do that. But you can transfer an interest in land. Now, what are the three interests in lands? Now, if you look at your course outline is divided into three. Who is that? Your course outline is divided into three. Now, your course outline is divided into three because those three segments signifies the interest in land. So once you discuss all the three interests in land, then that is all. The first one is a transfer, what you call a freehold interest. A freehold interest. Now, a freehold interest are those that claim they have a title deed over the property. Okay, that land belongs to them forever. That is a freehold interest. You have a freehold interest. The land belongs to you. When you die, that land goes to your descendants and your family and your kids and the kids of the kids of the kids of your grandmother. Are we together? So that is the first one. So it means, therefore, that I can transfer. When I'm selling that land, I am transferring that land to. Okay. Now, as a student of conveyancing, you need to stop using pedestrian languages. Once you step into a conveyancing class, you need to sound like your school fees. You know, KSL is very expensive. You can't pay 190,000 plus, and then you speak like a chief. Don't say I'm selling land. Speak like someone who went to Kenya School of Law. Tafadhali. Say you are transferring an interest in land. Hata ukisema hivi unasikia vizuri. Nasikia kichwa ina yeah. So say I'm transferring an interest in what? In land. So what does that mean? Anytime you see the word transferring an interest, anytime you you see a term, even in an exam, that someone is transferring an interest, the layman word is selling. They're selling it. Okay. Now you can transfer for value, for consideration, or you can transfer without consideration. We'll talk about all that. So the first one is a freehold interest. You have it forever. It comes from you. It goes to somebody else and all that. Understand? The second interest or the second part of your course outline is about leases. A leasehold interest in land. It means the land doesn't belong to you. You don't have a freehold interest forever. You have the interest for a specified period of time on certain terms. That is what you call as leasehold interest. So you have a leasehold interest. Now this leasehold interest, you can sublease it or you can sell it, quote unquote, you can transfer it. Now a freehold interest can be transferred. You can also lease it. You can also charge it because it is your interest. At the same time, if you have a leasehold interest, you can sell that lease to somebody. That is the transfer of leases or assignment of leases. Or you can even charge it, or you can even sublease it. We talk about subleases, okay? And then the last part of your course outline, which is the last aspect of your the interest in land, is charges, okay? Banks. Now, banks don't own land, more so in the context of charges. They don't own land. They don't have any other interest in land apart from a security interest. So they have a charge. It means if you charge your land to the bank can claim control over your land for a specified period of time because of an existing chargee being can hold a specified interest on that land for a specified
Jacktone, you're breaking.
depending on how
You're breaking.
pay your loan. So that is the system. How do you know I'm breaking? How do you know I'm breaking?
Because you're listening.
Because we can't hear you clearly. You're breaking up.
You first.
I'm breaking up.
We couldn't. Yeah.
All right. I'm breaking up. Breaking up with who?
Your voice is breaking.
Your internet. Yes, your internet or your network connection.
My friend. All right. Give me a minute. Is this still breaking up?
It's now stable.
Now you're good.
Still breaking up?
Better.
It's now stable.
We can hear you clearly. It's okay now.
Okay. Confirm it's okay.
It's okay, yes.
Yes, it is.
All right. So like I was saying, that the last interest is what you call the charge. So a charge is where the bank will have a specified interest on that property, which is just a charge, an interest, just a security interest. Once you pay the loan, the bank will stop having an interest on your property. Now, after saying that, I was saying that in the entire course, you only need to understand the three things. You need to understand freehold interest, transfers, you need to understand leases, You need to understand charges. That is all you need to understand. Now, everything else you'll talk about is within the three things. Are we together? Now, the next thing that you're going to understand, what you need to talk about, is the question around the legal framework. What is the legal framework that you need to understand? The Land Act, the Land Registration Act, both of 2012. Okay, the Land Act and the Land Registration Act of 2012. The Land Act is a substantive law, and then the Land Registration Act is the procedural law. Okay, both were enacted in 2012. Now, we have other things like the Constitution of Kenya, very, very important. Chapter 5 of the Constitution of Kenya talks about land and environment. Now, that specific chapter defines what is public land, or the different categories of of land: public land, private land, and community land. Okay, and then of course we have a very important act again, which is the Community Land Act of 2016. We will get to that when we start talking about community land. Okay, and then we have another important aspect of it, which is the SPA, the Sectional Properties Act of 2020. A very, very important legislation, and how we moved away from the 1987 Act and then all the way to the 2020 Act. That is the Sectional Properties Act, and what changed and what didn't change. We'll talk about that. Now, up to that point, is there anyone having a question?
Yes.
Why is your hand not up? All right, let's proceed. I don't think you're serious. So the next bit that we need to discuss is now the history of titles, a very interesting bit. We start with the history of titles. Okay, the history of title, historia. How do we call titles in Swahili? Waluya. I don't know the science behind behind Luyas thinking that they know Swahili even better than the original Swahili people.
Inaitwa cheti cha umiliki.
Cheti cha nini?
Umiliki.
Cheti cha umiliki.
Hatimiliki.
Cheti cha umiliki or hatimiliki? What are you guys saying?
Hatimiliki.
Yes. All right, so let's talk about the history of titles. Now, guys, you will need to understand the history of titles before you... Munene, someone call Munene. What is wrong with you? What is the question? I'm moving very fast.
Sorry, I was trying to put down my hand, but I wanted to ask, you mentioned the legal framework, but you didn't mention the regulations, for example,
That's
the
obvious,
legal
my
notice.
friend. That's obvious, my friend. That's pretty much obvious. If I mention Land Act, anything that comes under the Land Act, all the subsidiary legislations to the Land Act are part of that. So all subsidiary legislations, all of them are part of that. And like I've said, you cannot cram all of them. Okay, Monene, you can't cram all of them. You can't even know all of them. There are a lot of things that deals with land that you will not even know, and you can't cram all of them. You will die, like natural death, not like sickness or what. You just die. So don't kill yourself. Just stick to the basics. Okay. Each and every day, the government and the Ministry of Land comes up with a regulation. There's so many regulations. There's so many forms. If you go to that website, you'll find a lot of that. You cannot do all that. Even if they give you 10 years, you can't catch up. Okay. So just know that we'll talk about regulation 270, 278 and 280. Those are the main important regulations in terms of changes of users, extension of leases, renewal of leases, and all those rights in Alieno Solo. We'll talk about those regulations, but in as far as the main regulations are concerned and everything else, it is within the sections, the Act of Parliament that I've already mentioned. Kim, what is your question? All right, put your hand down and mute your microphone. All right, so let's talk about the history of titles, guys. This is a serious one. This is now the serious part that you need to understand. You need to understand the history of titles. Now, guys, you will not pass this one if you don't understand the history of titles. You will never masquerade or purport to even sit this paper if you don't understand the history of what? The history of titles. Why do we have titles? Where do they come from? Why do we have them? Because as an examiner setting the exam, I will be sending you a question, or I'll be giving you a question, and I'll be using a specific title. Now, at the back of your mind, you need to understand the inspiration of that title. Okay, so let's go back to 1963. Okay, what happened in 1963 versus what happened in 1964? Now, some of you in this class don't even know what is the difference between 1963 and 1964, as far as the Kenyan history is concerned. Wako tu hapa wengi kukula tu na manifestation kila siku. Ni sawa. So let's go back to 1963, because that is where we find a lot of things. Okay, now we used to have a lot of acts of parliament until 2012. We used to have a lot of acts of parliament. Okay, dealing with the land. We used to have the RTA, we used to have the RLAs, we used to have the ITPA, we used to have the GLAs. We used to have a lot of the SPA. We used to have a lot of acts of parliament that were dealing with just titles to land, or the question of conveyancing, just land. We used to have a lot of them. Okay, now when it came to, because remember that you know the ITPA, Now the ITPA came from India. The ITPA is the Indian Transfer of Property. Now that act came from England. Now when the English colonized India, they copy-pasted their conveyancing law or the land laws to India. Okay, when they moved to Africa, then they picked that from India and they brought it to Kenya. Oh my goodness, I don't like this. My network there is not working. Am I still breaking? Am I there?
Yes, you are.
You're good, Jack.
All right, I'm assuming I am. So I was talking about if you lose me for a second, you let me know so that I don't go on and on and on and on. So if you miss a point, you let me know. So I was talking about the type of legislations that we used to have way back in 1963, moving back to the 1900s. Okay, we used to have the RDAs, the Registration of Documents Act. We used to have the Section of Properties Act of 1987. We used to have the ITPA, like I was explaining, that the Indian Transfer of Properties Act of 1882 came from India. It was a copy paste from the Indian land laws, and it was, brought directly into our legal system. We used to have the RTA. Okay, that is the Registration of Titles Act. We used to have the LTA, that is the Land Titles Act. We used to have Registered Land Acts, that is Cap 300. Now, all those specific legislations used to provide for specific information or specific aspects of land ownership. Are we together? Now, in 2012, the government decided to consolidate the question of registration of titles. Okay, what am I saying? Now, in 1963, moving back to all the way to 1900, each and every act of parliament that was existing used to have its own system of registration. Okay, if we talk about the RTA, it used to provide for leases. It means all leases were registered under the RTA. If you talk about the GLA, it used to provide for the government lands. Every government land was supposed to be registered under the GLA. If you talk about the RLAs, it used to provide for freehold titles, and all freehold titles were issued under the RLAs. And that changed. Okay, that changed in 2012. Now, what changed was the system of registration, but the titles stayed. Okay, now in 1963, moving all the way to 1965, this is the period that now the whites and the British were moving. Okay, they were moving out of the country. Okay, as they were moving out of the country, the vast Kenyan islands and what we call the White Islands and every piece of land that was occupied by the British were being given back to Kenyans. Okay, now two things were happening. There are two reasons why the government was giving back land to Kenyans. There are just two reasons why the government was giving back land to Kenyans in 1965. Why? The first one was to promote agriculture. I want you to listen to this. The first reason why the government of Kenya was giving land back the government, back to the Kenyan citizens after the whites had gone, is because the government wanted to promote agriculture, and that's so the enactment of the Land Control Act. Now, the Land Control Act gave birth to one specific a board that we are calling the LCB, the Land Control Board. Okay, are we together? Now, the reason why we have the Land Control Act was the question of agriculture. The government was giving back land so that we can promote agriculture. Number one. Number two, the second reason and the final reason why the government was giving back land to the citizens was through urbanization, that we needed to promote urbanization and the growth of commercial centers. Are we together? So that is what used to happen. Now, the two specific acts of parliament that were facilitating this was the RTA, which is the Registration of Titles Act, okay, and then the RLA, which is the Registered Land Act. Are you together? Now, the RTA used to provide for leases, and then the RLA used to provide for freehold titles. Okay. Now, let us start with the RTA titles. So the history of titles begins from the RTA titles. Now we have different types of titles. We have the RTA titles, we have the RLA titles, we have the GLA titles, we have the LRA titles, we have the municipal titles, and then we have the SPA titles. Don't get confused. They are very simple things. So let's start from the RTA titles. So what are the RTA titles? So under each title, you need to understand, how do you identify that title? What is the nature of the title? And what is the extent of the required due diligence that is required for that title? So that when you see it in a question, you're like, okay, this title is this one is this, and this one is this. Guys, are we together? Okay. Jonjo. Now, let us start from Wanjala. Wanjala, put your hand down. Let us start from RTA titles. So what is it about the RTA titles? Now, RTA in full is Registration of Titles Act. Now, this specific act of parliament was enacted to facilitate the registration of leases. Now, before 2012, we used to have a dual system of registration. Guys, remember, I've said we have three interests in land: freehold, leases, and charges. Now, we used to have a dual system of registration. One system of registration was catering for leases. Another system was catering for freeholds. Now the RTA was supposed to cater for leases. Are you together? So the first thing is that RTA titles were leases. That is the first thing. That is the nature of the RTA titles. They were leases. And why were leases issued? The issuance of leases was for purposes of promoting urbanization. Okay? And that is why you will never find a freehold title around any town. Around the municipality, you'll never find a freehold title. Even in Nairobi, you'll never find a freehold title within Nairobi town. Unless the specific instances of corruption where somebody did something and then they ended up owning land within town. Nobody was supposed to own land within town. Nobody was supposed to own land absolutely within the towns. The land that were given on areas that were zoned for urbanization, Mombasa, Kisumu, Nairobi, Nakuru, Eldoret, pieces of land around those areas were meant for urbanization. And for the government to control urbanization, they were supposed to control the titles, thereby giving you leases for 99 years. And then after 99 years, they are able to control what happens to that piece of land because they need to be in charge of urbanization. So nobody was supposed to own land within town. You cannot have a freehold title within town. But of course, the few instances, if you read the Ndungu reports and everything, there are few instances where some people, the strong and the big and the who's, stole land and then they issued themselves freehold titles within certain areas within the towns. So the first thing is that RTAs were leases. They were leases up to a maximum of 99 years. Okay. Now, how do you identify an RTA title? Okay. Now, RTA titles had three things tied to the naming. The first thing is an LR. Any title that has an LR is an RTA title. Okay. LR. LR stands from land reference number. So if you see it in a paper, it will be L.R number this or land reference number this. Are you together? So that is an LR. Now an LR indicates an RTA title. An RTA title is a lease for 99 years maximum. Are you together? Now that is an LR. The second thing that you'll find on an RTA title maybe is an LR with a CR at the end or an LR with a IR at the end. LR with a CR at the end. So land reference number 123/1 CR. Okay. Or land reference number 123/1 IR. So what is the meaning of CR and what is the meaning of an IR? Now, the CR and the IR was supposed to tell you where to do your due diligence. What am I saying? I'm saying if you see an LR, that is an RTA title. Of course, it can come with a CR, it can come with an IR, or it can come with just a plain LR. So we have said RTA titles will have that kind of naming, LR. Sometimes you find it in full, land reference number. Okay. Now that is the second thing. We have talked about the naming. We have talked about the nature, which is the leases for a maximum of 99 years. It can be a lease for 20 years, for 10 years, for 40 years, but a maximum of 9 years. That is that. Now, the last bit of it is the question of due diligence. How then do we conduct due diligence on RTAs? Let's go to CR. Now, CR denotes Coastal Registry. Okay. And then the IR denotes Inland Registry. So an L. Who is that? Let me come for you. Disappear before I get there. Or mute your microphone before I get you there. I don't know why you're yawning. Why are you yawning? Huh? Is everything okay at home? Jawanja kitu. Cha. All right, so they're muted. So I've said an LR with a CR denotes coastal registry because CR stands for a coastal registry. It means that title is found at the coastal registry. And then an IR denotes inland registry. Are you together? Inland registry is in Nairobi. Okay. Now, if you go to Mombasa, there are two types of registries. The first one is the Mombasa District Registry, and then the Mombasa Coastal Registry. Okay. There's a principal registry in Mombasa, which serves the entire coast, and then there's a specific district registry for just the the Mombasa district. The same thing for Nairobi. If you go to Nairobi, at the land registry in Upper Hill, there are two things. There's the Nairobi District Registry and the Nairobi Inland Registry, the principal registry. Okay. Now the principal registry in Nairobi, which is the Inland Registry, serves all RTA titles on inland. That's why Elon wanasema whatever those things Waswahili keep saying. I don't know whether they make sense, but whatever. So if you come from Bara, your RTA title is in Nairobi. The register is in Nairobi. If you come from coast or the coastal regions, your RTA title register is in Mombasa. Are you together? So it doesn't matter. It doesn't matter whether you are in Kitale. Okay. If you get an RTA title in Kitale, you want to do a search, you'll have to come all the way to Nairobi or Mombasa, depending on that. But of course, the government made it sure that you will not find a CR in Nairobi, neither will you find an IR in Mombasa. So an IR will be around Nairobi and all the Bara regions, and then the CR will be around the coast. Are we together? So that is what we are saying. So in summary, we are saying RTAs, okay? RTAs are leases. They are leases for 99 years, okay? They are leases for 99 years. How do we name these leases? LRs, land reference numbers. Now, they come with either a CR, an IR, or just an LR plane. So if it is an LR plane, which does not show whether it is a CR or an IR, you can go either to Mombasa or to Nairobi, the principal registry, and do a search there. Number two, if it is an LR with a CR, you go to Mombasa. If it is an LR with an IR, you go to Nairobi. So don't confuse. It's a very simple thing. Okay. Are you together? It's a very, very simple thing. So that is what we call the RTAs. Now, these RTAs were leases. They are leases. Now, if you see somebody having an RTA title, the first thing you need to know is that, hey, this is a lease, okay? Now, if it is a lease, you just need to look for the number of years remaining on that lease, and everything else you know about leases will come at the back of your mind, so that you know as you proceed, you know you're dealing with a lease. When you're dealing with a lease, these are the things you can do on a lease. These are the things you can't do on a lease. It makes your work easier, even to advise, even on the questions of what kind of what are the tax implication, what kind of due diligence will you do. You will know because it is a lease. That is what we call the RTA. Number two, the RLAs. Now the RLAs were specifically again issued around 1963 all the way moving to 1965 until 2012. Okay. Now RLA titles came from the Registered Land Act. Now, this act was supposed to be the sister to the RTA. It was supposed to facilitate the issuance of freehold titles, what your father and your mother are calling title deed. Okay, that is what you're calling a title deed. They are meant to be freehold titles. Now, these freehold titles were meant, the first thing, what is the nature of freehold titles? They were meant to be freeholds. I mean, the RLA titles, they are meant to be freeholds. They are freeholds. Okay, why did the government issue RTAs? Urbanization. Why did the government issue RLAs? Agriculture. Are you together? That is why you will never find an RLA next to town. You will never find an RLA next to town because they were meant for agriculture. So RLAs were meant for agriculture and they are freehold titles. Freehold means you have it forever. When you meet your maker, your child will take over and your child will have it until they meet their maker, and the child of your child will take over. It is your land. Okay, you have an absolute interest in it. Are we together? Those are RLA titles. Okay, now one thing you need to understand is that all RLA titles are agricultural lands. That is what guys don't understand. All RLA titles are agricultural lands. What do I mean? It doesn't matter what your father is doing on that land. It doesn't matter what you're doing in that land, whether you are building a school on it, whether you've built a supermarket on it, whether you built a church on it, you know, it doesn't matter what you built on that land. That land was originally meant to be agricultural. Whether you are lazy enough not to till it, that is your problem. But whether there's a church there, you are going to deal with it as an agricultural land. And that is why if you're dealing with a consent, one of the consents you will require for RLA titles, which are freehold titles, you have to go to the LCB. Why do you go to the LCB? The LCB was created under Section 6 of the Land Control Board. I mean the Land Control Act. Now the Land Control Act gives rise to the Land Control Board, which is supposed to facilitate consents in terms of agricultural land. Now, in the eyes of the law, or anything that is RLA, anything that is a freehold is deemed to be agricultural. And therefore, you have to approach the LCB before you do anything on that land. Tuko sawa? All right. Tuko sawa. So I've said all RLA titles were meant to be agricultural. It doesn't matter what you're doing with it. It doesn't matter whether it is you've never tilled it or you're just keeping it there. You're building some commercial apartments on it. Okay. It doesn't matter what's happening on that land. So it was meant to be agricultural. Sawa sawa. So RLA titles are freehold titles. Okay, they don't have a term tied to it. Now, how do we name RLAs? They're the most common ones. How do you name RLAs? Now, RLAs add the name of a place, stroke a name of a place, or a block. So, Nairobi block, Nairobi stroke Langata, Langata stroke Karen, Ngong stroke Kajiado, Kajiado stroke Rongai. Those names, Kitale stroke Kakamega, Kitale block 1, Eldoret block 3, they are freehold titles. They are RLA titles. So if they were issued before 2012, they are RLA titles. Are we together? So that is the naming. So for leases, we have L.R. For RLAs, which are freehold titles, we have name of a place, stroke a name of a place, or a name of a place, stroke a block. Okay, we call them blocks. So Nairobi block 1, Nairobi block 2, Nairobi block 3, Kitale block 6, Kitale stroke Chikwekwe, Chavakola. Those funny names. I don't know why lawyers got those names from. So those are what we call the freehold titles. That is the RLA titles. And I've said they're freeholds. Now, let's go to the other thing, which is the question of due diligence. Now, we have said under RTA titles, the due diligence is done at the principal registries. And of course, one of the consent you'll need is the commissioner's consent. Anytime you're dealing with an RTA title, you need then the NLC consent. That is the National Land Commission consent, because it is the NLC that administers public land on behalf of the public, or sorry, on behalf of the government, and that is the national government and the county government. Okay, so that is that. So when you come to RLAs, the freehold titles, what is the nature of due diligence that is required? Number one, due diligence is done at the district registries. The district registry. So each and every district has got their district. If you are in Kitale, there's Kitale district registry. If you are in Bungoma, there's Bungoma district registry. If you are in Mombasa, there's Mombasa District Registry. Wherever you are, there's a district registry in that place. So if the title is in this place, you'll be told it is Thika stroke Nairobi. No, Thika is not in Nairobi. You know, people that stay on Thika Road, they usually confuse. Whether they're in Nairobi or not. If you're on Thika Road, the moment you pass TRM, wewe uko mashinani, you go Kiambu, Gatundu. Nairobi ends at TRM. So don't say Eshikamulu, Ruiru, Ruai. You are way out of town, my friend. Are you together? So that is important. So if you see a name of a place, to a name of a place, just pick the name of that place and look for the district registry. If Thika stroke this Ruaraka, you know it is Thika. I mean, I don't know that Thika is a district or whichever district, Kiambu district. Okay, so that is what we're saying. So all RLS titles, they do the due diligence of the district registries. Which consent do you need? The LCB consent. So that closes the RTAs and that closes the RLAs. Okay, now another thing that we used to have is called the GLA titles. GLA titles are very simple. They're government lands. Okay, government lands are the government lands. The GLA means Government Lands Act. So these are titles that were issued for government properties. The government properties. They're issued for government properties. Those people that took government properties or the large tracts of land that were owned by the big government officials, they were registered under the GLA. Now, GLA resembles the RTAs. The GLAs resembles the RTAs. They were leases, though they were leases for 1,000 years. 999 years were GLA titles. They were leases for 1,000 years. The good thing is that the government has done away with them. The government has done away with the GLAs, except around Kiambu. You still find some GLAs, of course, for the former president. You still have the Delamere farms around Naivasha, Nakuru. Those are still GLA titles. Okay, they're still GLA titles, but government has done away with GLA titles because having a piece of land for 1,000 years, at least for 1,000 years, is like having it forever. Nobody can live for 1,000 years in this world. Yeah, so the government has done away with those 1,000-year leases. Nowadays, it is 99 years that you renew. Okay, so that is GLA titles. They were registered. They were all the same as RTAs. They were leases, and they were registered specifically for the who's and the who's. You know, those whose fathers fought for pieces of land. Now, when your fathers were sleeping, other people's fathers were grabbing land everywhere. So that is GLA titles. Now let's talk about what we're calling the municipal titles. Municipal titles were titles that are issued under the municipal acts, what we call the county councils. So the county councils also had the titles that they issued to the people that they want to issue to. So we have the county councils that were given the mandate to also have titles. Okay, so under the county, I mean the municipal titles, these are titles that have been taken over by the counties. Because when counties came, counties replaced the old municipals. So how do you know a municipal title? A municipal title is it gives the name of the municipality. So Nairobi municipality, block this. Nairobi municipality, block this. Kisumu municipality, Eldoret municipality, it will have the municipality on it. So if it is a municipality, it is a municipality. Where do you do the search for municipal titles? Where do you do the search for municipal titles? The county commissioner. You need the consent of the county commissioner. Sorry, the district, the county registries, and also the consent is the county commissioner's consent. So you go to the county registry. You get your some of them have been merged with the district registries. So some of them you might find at the district registries, and the consent that is required for every municipal title is the county commissioner's consent. Okay, so that is what we call the municipal titles. And then lastly, we have the SPA titles. Now, the sectional property titles. Now they used to exist. They were called sectional titles, but they've been phased out with the new certificate of titles that we have and the certificate of leases that we have. So lastly, let's talk about post 2012. Now, all those titles I've given you were titles that were issued before 2012. What happened in 2012? The Land Act was amended. The Land Registration Act was enacted. Are you together? Now that brought us, something happened in 2012. So remember that before 2012, we have two separate systems. Leases. I'm seeing your hand. You're not excused. Put your hand down. Mute. I'll come after I'm done explaining this, the point that I'm explaining. Not taking questions right now. Now, like I've said, before 2012, we have two systems of registration, two separate systems. The first one deals with leases. The second one deals with freehold titles. Now, in 2012, the government says, no, we're done doing this. So what has the government done since 2012? They merged the two systems of registration and said, whether it is a lease, whether it is a freehold title, all of it is going to be issued under the Land Registration Act of 2012. And that gave us what we call the LRA, the LRA, Land Registration Act of 2012. Now, this is the one that now merged three systems. The first system it merged is the RTA system, the RLA system, the SPA system. All those three things were merged into one system of registration, so that if you apply for a title after 2012, you will get an LRA title, whether it's a lease or it is a freehold. The naming is the same. Everything is the same. Are you together? Everything is the same because we have merged them. So how do you differentiate between, I'll come back. Let's start with naming. Let's start with the naming. So how do we name the new titles that we have? The new titles that we have adopted the naming of the RLA titles. Name of a place, stroke a name of a place, or name of a place, stroke a block. So the new titles after 2012 also adopt the naming of Nairobi block, Nairobi stroke Langata, Langata block 2, Kitale block 3. That is the naming. This naming was under the freeholds, but now we are adopting them under the new Land Registration Act of 2012. Okay, how do you do your due diligence? District registry. All LRAs are done at the district registries. What consent do you need for LRAs? I've said if it is a lease, NLC. Okay, if it is a freehold, it is the LCB. Now, don't forget that the titles that were issued before 2012, they are still valid. It doesn't mean that now we have phased them off. No, they are still valid. You still have your RTA that was given to your father in 1960. Your father will still have it. It is still valid. But if you have to do a search on it, you still go back to the places that I've said. The principal registry is either in Mombasa or in Nairobi. Are you together? So those titles that were issued, they are still there. They're still very, very valid. But if you are applying for a title after 2012, we are giving you a new one, which is the LRA title. It adopts the naming under the RLA, which is the name of a place, stroke a name of a place, or name of a block, stroke a name of a block. Okay. Now, these titles that are issued after 2012, they are both leases and freeholds. Okay, they're both leases and freeholds. So you look at the title. Is it a lease or is it a freehold? So the title will tell you if it is a lease or it is a freehold. If it is a lease, you have to give us the NLC consent. If it is a freehold, you have to give us the LCB consent. Are we together? Okay. Now, how do you differentiate between the LRA titles issued after 2012 and the RLA titles, freeholds that were issued before 2012? The year. Look at the year the title is issued. If it is issued after 2012, then chances are it is either a lease or a freehold. if it is issued before 2012, it is a freehold. What am I saying? I'm saying that in an exam question, you see a title called Ngong stroke Kajiado. Maybe the land is based somewhere in next to Rongai. People in Rongai think they're in Nairobi. My friend, hujafika Nairobi bado. Acha kuambia watu ushago kwa Nairobi. In Rongai, kwa mashinani, kwa Masai. Okay? So Ngong stroke Kajiado. Are you together? So if it is Ngong to Kajiado and you're in an exam, you're being told that James is the proprietor of land title Ngong stroke Kajiado, issued or from 2013. Okay. Now, if it is issued after 2012, this title can either be a lease or can either be a freehold. So you have to read further and get the details. If it is the examiner will tell you if it is a lease or it is a freehold. Or if you have a physical title, the title will tell you. Or sometimes the examiner will give you an extract of the details, some of the details on the title. So you'll know if it is a lease, if it is a freehold. However, if you're told that this guy got a title in 2002 and it is Ngong stroke Kajiado, that is essentially a freehold. Tuko sawa? So that itself gives us the summary of all the titles that we have. So I've said, remember, to summarize that point, I've said that the titles that were issued before 2012, they are termed as the old titles, but they are still valid. They are very, very valid. The RTAs, very valid. Leases, very, very valid. The RLAs, very, very valid. But what the government said in 2012 is that, hey, we can't have three systems of registration. We have the Section of Properties Act, Section of Titles. At the same time, we have RTA. At the same time, we have RLA. Let's merge them together. So the government merged them together and then started issuing new titles. But the government did not declare the old titles. The old titles, invalid. Are you together? That is what happened. But now the government has started a process, which we're going to discuss, of ensuring that even those old titles are converted to conform to the new titles. And that is what we call conversion of titles. Conversion of titles. So our next topic right now is the conversion of categories of land, stroke titles. Questions? Beba mikono juu. You have 2 seconds. All right, let's proceed. No one has a question. I thought someone was calling my name. Thought they have a question. No one has a question. Mudeo, I'm only taking a question from Mudeo. Mudeo, what is your question?
Sorry, you can hear me?
Mm-hmm.
Just a clarification. When you're speaking about those titles issued after 2012, you said the consent for lease is supposed to be issued by the National Land Board, and for freehold by
National Land Commission, NLC,
Oh, sorry.
National Land Commission.
and the one for the freehold by LCB.
Yes, kama kawaida. Mm-hmm.
Oh, sorry, I just wanted that clarification. Thank you.
All right, get to what is your question, guys? One rule in this class: if I ask you guys to put up your hand, you have 2 seconds to put up your hand. So if I'm proceeding with something, you note down your questions, note them down so that they don't disappear. Once I give you time to put up your hand, you don't wait until. Okay, get to lastly. Get to what is your question?
Good evening, Jacktone.
Mm-hmm.
Kindly, could you repeat the point on SPA? What do you say about SPA?
What did you hear about SPA? Tell me what you know about SPA, and then help you from there.
That point is keeping me because there was some noise in the background, in my background.
So how can I help with the noise from your background? Can I come to your house and beat those people up thoroughly for you?
Kindly, just I'll appreciate if you. Right now, my background is clear, and if you don't mind, kindly, if you repeat what you said about SPA.
No, I will not do that because now that will take us back and back and back. I mean, I put your hand down. I said SPAs are Sectional Property Act. I mean, Sectional Properties Act. The titles that were issued for SPAs. There were titles that were issued for SPAs. They were called sectional titles. 1987, sectional titles. 1987. Now, in 2012, the Land Registration Act now says we don't have sectional properties anymore, sectional titles anymore. So any title that were issued, that is being issued under Sectional Properties Act, we are also going to call them the same name we are calling these ones. We are calling them certificate of leases if they're leases, or certificate of titles if they're titles. That is what I've said. So we no longer have sectional titles. We have certificate of titles or certificate of leases. Tuko sawa?
Yeah, sawa, tuko sawa.
Aya. So guys, if you still have a question, note the question down, and then you put up your hand the moment I say you put up your hand. I don't entertain people putting up their hand in continuous motions. Can't happen, won't happen. All right, next topic. The question of conversion of categories of land. Now, I've said there are two things. There are two aspects of conversion. We are converting land and we are converting title. Don't confuse those two things. Let's start with the conversion of titles. We'll discuss it in details at some point later. What is conversion of titles? Now, I've said we have gone through the different types of titles, the RTA titles, okay? We have gone through the RLA titles, the GLA titles, the SPA titles. We talk about all those types of titles that were issued before 2012, okay? Now, after 2012, now there are new titles. After 2012, there are now new titles that are being issued, okay? Now, this title, someone, can you mute your microphone? Ayim, Joe, I'll throw you out. All right, so I've said that these titles are being issued in 2012. They are new titles, and they are titles that reflect the provisions of the Land Registration Act of 2012. Okay, now the question then is, what happens to the old titles that we have? The government now said, hey, the Ministry of Land, from 2020, we need to convert them. We will convert them. If you have an RTA, if you have an RLA, don't worry. We shall convert them and give you the LRA. Okay, so simply the government is saying that all titles must be issued under the RLA, the new RLA, the LRA, sorry, the new LRA, that is the Land Registration Act of 2012. All titles must be issued under it. Then the question that we're asking at the background is, what about us who got titles under RTA? What about me who got my title deed under RLA? Then the ministry is saying, don't worry. We are going to convert that title that you have to conform with the new LRA. That's what we call conversion of titles. So we are converting old titles and giving you new titles. So how do we do that? We make an application, we advertise. There's a process, we'll discuss that. We advertise, you surrender your old one, we give you a new one. Just like the process of conversion of number plates. Okay, number plates. So you've heard the government is trying to convert number plates to the new number plates. If you have a car that you bought some time back and you have the old number plate, the government is simply saying, hey, you know, plate yako kuna venye hatuipendi. So bring it, give the NTSA your old number plate, and then we give you the new number plate. It's the same thing. You have a title from back. We are saying, give us that title, we'll give you the new one. Okay, that is the conversion of titles. Now, the most important part of this discussion is the conversion of land. conversion of categories of land. Let's go back and talk about what are some of the categories of land that we have. Now, this is a very important question. People usually ignore this question until it gets to the point where things start to bite each other. When things start to bite each other in that exam room, my friend, when you're doing the exam paper, you will sweat until your ears. You know, you'll even forget your name. It happens, by the way. You forget your name instantly. You don't even remember where you came from when you're coming to do that exam because things have beaten each other very well. So before things get to the point where they're biting each other, understand the concept. Like I've said, conveyancing has a lot of sections of law, has a lot of provisions, regulation, and everything. You can't cram all of them. You just need to understand the concept. Nobody cares about what section of the Land Act. Nobody cares whether it is section 28. So long as you know the overriding interest, you don't have to tell me section 28. So because it is a procedure, name the procedure. It is not theory. This is not theory. It is procedure. So we don't care about whether you know the sections or not. Just know the concept. Now, what is the conversion of land and what is the difference between conversion of land and conversion of titles? I've told you what conversion of titles are. Now, what are the three categories of land? The first one we have is public land. Now, public land as defined under the Constitution is any land that is being used for public purposes. Any land that is owned by either the national government or the county government, and the purpose is publicly motivated. Are you together? That is a public land. So go to that is the first assignment of the day. Go to the Constitution, chapter 5 of the Constitution, and read on what is a public land, what amounts to a public land. Okay, government buildings, national parks, mines, natural places, housing natural resources, lakes. Those are public land. Okay, and then we have another thing we're calling private land. Now the land that belongs to you, the land that belongs to you, the land that you have a title deed over, that is your private land. Okay, and then we have what we call a community land, the land that belongs to a community, the land registered in the name of the community. Okay, now what is conversion of land? Conversion of land simply means we can convert a public land to a private land. We can convert a private land to a community land, and we can convert a community land to a private land, and vice versa. So the three categories of land, we can convert it like back and forth, back and forth. That is what we call a conversion of categories of land. Now we look at section 9. Section 9 of the Land Act talks about the question of conversion of land and how you convert public land to private land and vice versa, and the other side also. Okay, that is what we call conversion of land. So what is your first assignment of the day? Chapter 5 of the Constitution. Read the entire chapter 5 of the Constitution. Now, specifically, it provides for the following three things. The first thing are the different categories of land that we have and what amounts to public, private, and community land. Number 2, it talks about the role of the National Land Commission. What is the role of the NLC? We have the National Land Commission. What is the role of the NLC? What does the NLC play in as far as administration of government land is concerned? That is provided for under the Constitution. And then the question of foreigners owning land. A foreigner cannot own land, freehold land, except at least for 99 years. That is also under the Constitution. So I've essentially done your assignment for you. Okay, and then section 9 on the question of conversion. So don't confuse conversion of titles and conversion of land. Okay, for instance, if you want to convert a public land to a private land, you can transfer it. The government can sell you that land. Though the government is not supposed to sell you the land, the government can transfer it. Yes, you can transfer a public land to someone else, and that becomes a private land. You can allot. That is allotment. Normally happens. The government can decide that they're going to allot a specific piece of land to someone. That is allotment. It converts that land to a private land. And of course, questions to do with point is gone. So normally questions of allotment or long-term leases. If you have extremely long-term leases, it gives you some long-term private interest on that property before it goes back to the government. Okay, so that is the question of conversion of public to private. If you're having a private land, how do you convert a private land to a public land? Number one, compulsory acquisition of land. The government can tell you, hey, hii shamba yako tunaitaka. Now, all lands belong to the government of Kenya anyway. Okay, all lands belong to the government of Kenya, and that is why we keep saying the law of the land, the law of the land. So the land, the Kenyan law is called the law of the land in Kenya. So when you are converting a private land, the first way is through what we call compulsory acquisition of land. The government can take your land. Okay. Number two is what we are calling surrender. You can surrender your land back to the government. Also, if it is a long-term lease, you can surrender it back to the government. Okay. Transfer. You can transfer your land to the government. You can sell your land to the government. The government can buy your land. Okay. The government can buy your land. There are certain instances where the government has bought land belonging to certain people because of certain reasons that they have. So the government can also buy your land. So you can surrender the land back to the government, you can transfer the land back to the government, or the government can compulsorily acquire it. Okay. And then we have now the community land, same process. The community can surrender it back, the government can take it forcefully through compulsory acquisition of land, or the community can sell it back to the government. It's the same thing, and vice versa. So my main aim right now is to ensure that you don't confuse conversion of titles and conversion of categories of land. Conversion of titles, there's an entire guideline and the entire process of conversion of titles. We are going to discuss it later in the unit. And conversion of land is under section 9. But before you read section 9, you just read the Constitution to understand the different categories of land that we have. Now, with that said, I want us to talk about, you have 2 minutes, 2 seconds to put up your hand if you have a question, and then we can go and talk about the question of registration and the overriding interest in land. Esiroyo versus Esiroyo. Obiero versus Opio. Amina, Shoshi. Shoshi. As from the lake, we don't know how to pronounce that one. Amina, proceed.
Okay, it's Amina Shosi.
Show what?
Shosi.
Yes, sawa.
Okay. Yeah, I am a bit confused in the Land Registration Act titles. You said that the freehold get consent from the LCB, the Land Commission Board. I'm trying to understand, like, how is it a freehold and you still need consent from the LCB?
All right. Now, who sits in the LCB? Let's start from the history of the LCB. You know, the LCB are the village elders. There's really there's nothing special about LCB. LCBs are just the I don't know, where is your village, Amina? Do you know where your village is?
In Malindi.
Where in Malindi?
Jela.
What?
Jela.
Hela ama Jela?
It's not Jela, it's Shela.
Oh, Shela. Natoka Shela. Sawa, mtu wa Shela. Sasa, from Shela, what normally happens is that some village elders, people that have grown in that Shela area for a long time, few of them are picked to form part of the LCB. Each and every district has got an LCB. Okay, what is the work of those people? They are supposed to confirm that, hey, this land belongs to Amina. We know Amina, and this land belongs to them. Are you together? So the LCB, it is a freehold land. Remember, one thing you need to understand is that all lands. The principle is this: the eminent domain. All land belongs to the government. Like I've said, nobody owns land. Shamba si yako. What you have there is an interest. And who gave you the interest? Serikali ndo ilikupea hiyo interest. So it is a serikali land. So anytime you want to sell your land, you have to tell serikali that this land that you gave me, I'm selling it to my friend. Okay? So every type of land, you will need a consent. You will need a consent. If it is a freehold land, like I've told you, it was meant to be agricultural. And therefore, the party that is controlling freehold lands and agricultural land is the LCB. You have to go to the LCB and confirm with the LCB. So the LCB is supposed to confirm that, hey, this land belongs to you, and whatever you want to do with this land is right. Okay? So it's just about telling the government. Just about telling the government. The land belongs to the government anyway. You're just enjoying it for a few times. The government can wake up one day and say, hey, we want the land back. Huwezi sema eti hii shamba ni yangu, mbona mnataka kuichukua? No. All lands belong to the government. You have to notify the government at any time. But if it is a lease, you have to now talk to the National Land Commission, the commissioner's consent. But if it is a freehold, you just notify the LCB. Tuko sawa? Shela.
Yes,
Tuko,
yes.
tuko sawa? Aya. So that is Amina. Sawa, Amina. So put your hand down now. Let us go to the other aspect that I want to discuss, which is a question of registration of land and the overriding interest. Guys, this is the most important part for you to understand moving on. Registration of land, the effect of registration and why we register land. So we have something called registration. Okay, each and every land, Amina, your hand is still up. Each and every piece of land must be registered. Why do we register land? Why do we register land? Somebody put up your hand and tell us as much as you can. You guys don't participate. Somebody, I'm going to pick you guys. So let's start from, if no one is putting up their hand, let us start from Jacqueline. Jacqueline, why do we register land? Why is it important for land to be registered? Jacqueline? Jacqueline Atonga. All right, she's not there. Let's go to people that have their hand up. Let's start from Kipkoech. Dennis, why do we register land?
Thank you so much, Jacktone. We register land so that so that we can utilize the proprietary interest in it, for instance, securing a loan.
Kerry Odhiambo.
Purposes.
Kerry.
Yes.
What?
Taxation for payment of stamp duty is a way of income for the government.
Why are you sounding that you want to cry? Tax is making you emotional.
I'm saying. I'm saying that one of the purposes or the goals of registration of land is to aid the government in collection of taxes.
Yes, it's true. It's true. So taxation, tax. Ushuru lazima tulipe ndio tujitegemee. Wakiaga.
Yes, registration of land defines the persons whose interests are in those lands, and this reduces litigation.
Okay, litigation. Fatma,
efficient land management, as registration facilitates efficient land management processes.
Yes, efficiency in terms of land management, and among others, what we call. Yes. So guys, those are the reasons why we register land. First, to establish the proprietary interest of who owns that land. Purposes of to avoid fragmentation, that is subdivision and subdivision and subdivision. Questions of taxation, avoiding litigation and conflict, and of course the question of proper management of the specific land. Okay. Now each and every land is registered. Now, what is the benefit of registering a land? The main benefit of land being registered in your name is that it gives you all. It gives you, and I want you to listen to where I'm heading to, because that's where it gets it becomes very confusing. We register land for the purposes for the things that we have said, but the most important thing right now that I'm mentioning is that when you register land, the person in whose name land is registered obtains what we call absolute proprietary interest to the exclusion of everyone else. What is that supposed to mean? In simple terms, we're just saying, hey, hii shamba ni yangu. Okay, hii shamba ni yangu. Na juni yangu, sitaki uingie hapa ndani. That's what we're saying. This is my land. I can do whatever it is that I want with it. That is what you're saying, that when you read Section 25 of the Land Registration Act, it says that registration of land gives you the absolute interest to the exclusion of everyone. Now, we have something which is an exception to that rule called the overriding interest. Guys, I want you to move with me. Where am I starting from? I'm starting from the point where I'm saying we need to register land. Land must be registered. And that is why we have what we call the Land Registration Act. Okay, we register land for all the reasons, including to give government the taxes. Okay, but most importantly, we are registering land so that the person whose name is appearing on the title deed or on certificate of lease or certificate of title, that person obtains what we call an absolute interest that cannot be defeated by any other person's interest. Okay, so that is the general rule. What is the general rule, guys? You see this and you'll apply it in your exams and everywhere else. The general rule is if the title deed reads your name, then it means the land is yours and you have a better interest that cannot be defeated by any other person for any other purpose. Okay, what is the exception to that rule? What we call the overriding interest. The overriding interest. What are some of the overriding interests in land? Now, guys, from the schools that we went to, that I went to myself, is a great school back in the day, still a great school up to now. We were taught that when something is overriding, it goes way and above the general rule. So when I say an overriding interest, what is an overriding interest? This is the interest that is more important than the fact that the land is registered in your name. As a layman, what would I say? Shamba ni yako, lakini, the moment I add lakini, I introduce an overriding interest. Like hatukatai shamba ni yako, but these are the things you can't do. These are the things that works with the title. You can't change them. They work with the title. And that thing is called the overriding interest in land. The first one that was deleted, of course, that is under Section 2.8 of the Land Registration Act. The first one used to be a matrimonial interest. That one stopped. They deleted it so that and this also will confuse you a lot of times, even when you talk about the aspect of conveyancing. What is a matrimonial interest in land? Okay, and I want you to understand from this perspective so that you argue as an advocate, you argue as a lawyer who understands what they're saying. Don't just argue because there's a platform for argument. We're in wakili. Okay, now the question of matrimonial property only arises under the Matrimonial Properties Act. Let me say that again. The question of what a matrimonial property is only arises under the Matrimonial Properties Act. That's number one. Number two, the Matrimonial Properties Act is only invoked during a divorce. Understand that? So on the question of matrimonial properties, you only invoke that during a divorce. And why? Because we are trying to establish what we are calling contribution. So for us to establish what is called contribution, we need to identify what is a matrimonial property. And therefore, this is a property that was obtained or was acquired after the commencement of this specific marriage. So without divorce being in the picture, there's nothing called a matrimonial property. The only exception that is given is under the charges where we are talking about a matrimonial home. A matrimonial home is now the place where you're staying, you and your wife, not you and your boyfriend. When you're cohabiting somewhere in Rongai, Gatak, or somewhere in Langat, or South C and South B, that is not a matrimonial home. Okay, it must be a matrimonial home. A bedsitter cannot be a matrimonial home. Are we together? So when we talk about a matrimonial home, it's a place where yourself, your legal wife, and your children are staying. Now, the only one time that place is mentioned in the in the Land Act is on questions of charges, where we are saying that you cannot charge a matrimonial home without the consent of the spouse. And that is which case? O'Brien versus Barclays Bank, which is a principle of separate legal advice. Anyway, so don't confuse matrimonial property and matrimonial home. Matrimonial home is relevant when it comes to charges. Matrimonial property is relevant in divorce on the question of contribution. Sawa sawa. So after that, let's talk about other overriding interests. Now, this interest, they override your interest. Okay? They override the interest that you have on the property. It doesn't matter. It doesn't matter what interest you have on the property. It doesn't matter. These are overriding interests. The first one are easements. Easements. Okay? What are easements? Now, for instance, right to access water. Right of way. Okay? What we call right to light, air, support. Those are easements. Okay? They go with the land. How do I mean? I mean, if you have a piece of land and over time, people have been using that piece of land as maybe access to another piece of land. If there's a way passing through your land to another land, okay? And you sell that land to James. James cannot wake up and say, hey, hii shamba ni yangu sasa, I'm closing this way. You can't close the way because right of way, right of water, right to support, air, those are easements and they're overriding interest. We are saying we don't care whether the title is in your name. What we are saying is, regardless of who buys this land, there must be a right of way here. So you cannot stop the right of way because the land belongs to you. Another one is called what you call restrictive covenants. What are restrictive covenants? I'll give an example. If you're coming from Bungoma or Kakamega or Shinyul, Shikwekwe, Shavakol, Shamakok, those sides, and you come to Nairobi and you buy a piece of land somewhere in Karen or somewhere in Kileleshwa, and you want to construct a posho mill there. You can't construct a posho mill in the middle of Kileleshwa. You can't. Or somewhere in Runda. You can't. Essentially, we are saying, hey, my friend, shamba ni yako atukatai, lakini hii posho mill yako, you can't construct it here. Why? Because there is an existing restrictive covenant that this place can only be used for quiet, residential, places. It is only for residential purposes. Okay, or you go and you want to build, let's say, a 30 floor apartment somewhere in Karen. They will tell you, hey, my friend, we appreciate where you are coming from. Shamba ni yako, wewe ndio umelipa, title deed ni yako, lakini hapa kwetu you cannot construct a house that is more than 1 floor. That is a restrictive covenant. It restricts and they're overriding interest. It doesn't matter whether you sell that land, they will move the land. Whoever gets that land, they'll be subjected the same right. Another one is what you call the leases. A lease is an overriding interest. What do I mean? For instance, today you are staying in an apartment. I'm assuming that you are staying on you are renting some apartment somewhere in Nairobi or wherever you are. And in that apartment, maybe you are 10 or 30 of you. Now the owner of that apartment can sell that apartment and say, hey, I'm selling my apartment to the new person. Okay. Now, how is a lease being an overriding interest? How is that being an overriding interest? We're now going to say, because you're a tenant, you have a lease on the property. You're leasing the property. You're a tenant, you're leasing the property. You're a lessee. Okay. The landlord is the lessor. Okay. The landlord has decided to sell the entire land or the entire property to someone else. Now, the new someone else that is coming will be bound by the leases that are existing. So he cannot come and say, hey, I've bought the apartments. I want you guys to live. I want you guys to live so that I can bring my own people. I have 13 children, like my uncle. I have 13 children and I want them to stay here so you guys can live. That cannot happen. Okay, that cannot happen. So if he buys the apartment, he will be bound by the existing leases. Because if you sell a property that has a lease, it moves with the lease. So you'll become the new owner of the leases. Okay? So he cannot say that I want you guys to vacate. No. The leases, short-term leases or the long-term leases, they move with the property. So I've said we have the easements, restrictive covenants, we have leases, and then of course we have what we call the way leaves. What is a way leave? Okay, a way leave is the right that the government will have on that land that allows the government to construct some, what do you call them? Sewage lines, telephone lines, water pipes, all those things, you know, that the government can construct on a property. So you cannot say that, hey, shamba ni yangu, mi sitaki pipe ya maji ipite kwa shamba yangu. No, you can't say that. Those are things that the fact that you own land, they will land, water pipe must always go through your land and you can't say no. So in total or in summary, we call them overriding interest. Kwa Kiswahili tunasema hatukatai shamba ni yako, lakini kwa sasa kuna vitu zingine huwezi kataa tusifanye kwa shamba yako. Is it shamba lako ama shamba yako? I think one of the useless courses that people do in high school is Swahili. I don't know why people do Swahili in the first place. It's a very useless subject. But anyway, the shamba lako ama shamba yako ama shamba zako, whatever that thing is. Okay, so that is what you're calling overriding interest. In short, the land is yours. We are not saying no, but there's things you can't do. Number one, easements, restrictive covenants, way leaves, leases. Okay, and then the last one is what you're calling the customary interest. The customary interest, like Esiroyo versus Esiroyo, Obiero versus Opio. That is one of the cases, very, very funny cases you'll find in your conveyancing class initially. So in those cases, the question that the court had to interpret is the question of, if I'm the firstborn in a family setting, my father registers my name as the proprietor of this property. Is that land can I evict my brothers and my sisters from that property? The courts have already said no. Why? Because it is a customary thing for the firstborn to get land registered in their name for the benefit of the siblings that are to come. So the fact that there's a customary interest on the property, it came from your grandfather, it went down to your father, is now, on you. So you cannot say that this is now my property. No, you have a right on the property. Yes, you're the registered proprietor, but there is an overriding customary interest on that property. And the cases in point are Esiroyo versus Esiroyo, Obiero versus Opio. Now, guys, that in itself concludes the introductory part of conveyancing. What you need to focus on when dealing with conveyancing, that summarizes all. If you allow me, I will now start on the conveyancing procedure, maybe give you a summary of the procedure, and then you can adjourn. Unless somebody has a question, we've talked about everything that I wanted you to understand in as far as the introductory part is concerned. Now, guys, if you don't understand anything else up to where I am, don't proceed. Don't read further. Just make sure you understand everything up to where I've reached, because that is the foundation of understanding conveyancing. If you don't understand it, conveyancing will bore you up. Conveyancing will bore you up, seriously bore you up if you don't understand that point. So the concept of land, importance of land, where we have land, what are some of the interest in land, which titles do we have, okay, what are the issue of titles, what is the nature of due diligence that we need, and then the question of categories of land and how we convert them, and even conversion of titles, and then the question of interest, registration, and the overriding interest. Okay, so two questions, one from Joy Waruiru, and then another one from Nash.
Okay, thank you. I just wanted to ask about the way leaves, where we said the government reserves the right to construct, say, sewer lines on the property. Is the government entitled to remunerate the owner of the property?
Yes. Yes. The government cannot do anything without paying. The fact that all lands belong to the government doesn't mean the government. Can you hear me? Hello?
Yes. Yes, we can hear you.
You can hear me?
Yes.
Yes, I'm answering and saying, yes, the government must compensate you. The government must compensate you. The government must compensate you for anything. If the fact that the land belongs to the government doesn't mean that they just wake up and come and take your land. No, even when they take it compulsorily, there's compensation process. Whether they are going to construct just a pole of, an electric pole, that area that has been covered by that electric pole must be compensated. So there's normally how they count it, they calculate it, and then they compensate you for the area. If it is a water pipe, they'll calculate what area has been covered by this water pipe, and then they will compensate you. So yes.
Okay, thank you.
Wakiaga, is it Wakiaga? Yes, Wakiaga.
Yeah,
Oh,
that's
Nash
my
first.
question.
Wakiaga, put your hand down. You're late. Nash.
Okay, I wanted to ask.
Wait first, Nash. Nash, is that your name? Are you Nash? What is Nash?
Yeah. Yes.
What is Nash in full?
Nashilu.
Nashilu. Where are you from, Nashilu?
Samburu.
Oh, from Samburu. So, ask your question.
I wanted to ask, the restrictive covenant is between who and who, or rather who makes it?
The restrictive covenant is binding. It is usually there's something called zoning. The county government zones places. Like if you go to Nairobi, the government has zoned industrial area. It is zoned for industries. You cannot go there and say I want to construct my residential house here in industrial area. Some places have been zoned for agriculture or for grazing. Okay, so the moment some places have been zoned for residential. Okay, so the moment a place has been zoned for something, then there's a restrictive covenant. Also, that is the first one. Sometimes also that is the obvious way of creating a restrictive covenant. Kibet Evans, put your hand down. That's the first way of creating a restrictive covenant. The second one is through people in that specific area, they agree, okay? The community agrees that, hey, for us to live in peace, there is no keeping of cats in this area, or there's no doing this, there's no hooting. When you come back from work, don't hoot. Or we are going to use this road for this purpose, or this road will pass through this place, or don't construct a house past this one. So normally it's about the government policies, the county council, and the community itself. Okay.
Okay, thank you.
All right, so thanks. Now, guys, on to the big, what do you call, the elephant in the room, conveyancing. What is the conveyancing process? Now, guys, conveyancing is divided into three. There is the transfers that involves transfer of interest in land, freeholds, and leases and charges. And then we have leases, and then we have charges. As an examiner, they will be asking you, advise James on the process of transferring this interest. That is the process of conveyancing. Now, the process of conveyancing is the same. It is the same, okay? It is the same. The first one is the question of due diligence. I'm just giving the summary, and then we hit the first one. So, due diligence, okay? It means if somebody was asking, describe the process of charging this land. James has a piece of land in Kakamega. James is trying to sell this land so that he can get school fees for masters or even KSL or just to enjoy. Advise James on the process of getting finances for this entire thing. Okay, so the first thing, whether you are leasing, whether you are charging, whether you are selling, all that must come from due diligence. So the first thing is due diligence. Are you together? The first process is due diligence. It doesn't matter what you're doing, you have to do your due diligence. Leases, charges, and transfers. Okay, number one. Number two, once you do the due diligence, the next thing is drafting. Okay, drafting. So after you do your due diligence, you will draft. If you are transferring the land, you are selling the land, you will draft a sale agreement. If you're leasing the land, you will draft a lease agreement. If you're charging the land, you will draft the charge. There are just three things, guys. It is not complicated. It is not rocket science. It's a very simple thing. If you did chemistry, you did maths in high school, you did biology, you did physics, you did all those things. They are harder than conveyancing. Conveyancing is very easy, very basic. We're just saying, I want to sell my land. Your grandmother at home is selling your land, and she's asking you as a wakili, and asking you, my grandchild, you're a wakili. I want to sell this land of mine. Advise me, where do I start from? You'll tell your grandmother that, hey, because of this and this, lazima uangalie hii shamba ni ya nani. Okay? Ilitoka wapi, kaenda wapi, kakuja wapi, kaenda wapi. That is due diligence. Okay? After that, we go to drafting. We draft the important document in the transaction. Guys, are you with me?
Yes.
Yes.
You draft. If it is a transfer, you draft a sale agreement. If it is a lease, you draft a lease agreement. If it is a charge, you draft a charge agreement. Perfect. Now, what is the next thing after charges? The next thing after drafting is what you call the completion stage. Now, the completion stage involves a lot of things. Okay, it involves a lot of things. One thing it involves is the question of consents. This is the stage where you're going to get the necessary consents that are required. Consents and approvals. Okay, consents and approvals. The next thing that is required here is the question of valuation if it is needed. Valuation. Okay, if it is another thing that is required here are the completion documents. Okay, and the next thing that is required here is payment of stamp duty. So the completion stage is a general stage whereby the parties to that transaction are going to do a specific thing or specific things. The first one is a question of consent. What do we mean consent? Now, if I'm selling land, the person that is selling, the vendor, during the completion stage, he's supposed to get busy in doing what? In making sure that he gets the necessary consent. If there's an LCB needed, they need to get the LCB. If it is an NLC needed, they need to get that. If it is spousal consent needed, it is time to talk to your wife. Speak nice to your wife. Pamper your wife. Treat her very well so that she can give you the consent. Okay? If it is an approval needed from the county government, go to the county government and get the approval. So this is the time to get the necessary consent and approvals. Okay? Number two, it is the same stage where you need to do valuation. The property is valued at this stage. Okay? It is the same stage where we are going to have the completion documents prepared. For instance, if it is a transfer, what are the completion documents I will need? I will need a signed transfer from LR33. We need LR33. That is a transfer document. It needs to be prepared by the purchaser and duly signed by the vendor. Okay? I will need the consents. I will need your ID. I will need your KRA. I will need your passport. Okay? If it's a company, I will need the certificate of incorporation of the company. I will need the resolutions, the minutes. Okay? So those documents are required during the completion stage. Okay? If it is a lease, we will need the consents. I will need a duly signed lease agreement. If it is because it is a lease, if you are leasing a lease, you'll need to get the consent from the NLC. What do I mean? You're leasing a lease. I've said shamba ni lease from the government. That is a 99-year lease. Umepewa hiyo lease. Wewe pia after umepewa lease, umeamua kupea mtu mwingine lease. That is what we call a sublease. So you're subleasing it to someone. Before you sublease, go back to the head lessor, that is the government, and get a consent. All that we will need here. Now, if it is a transfer still, we need to do the valuation. We need to value the property and say, hey, this property needs to be valued. Why do we value? We value so that we can pay the stamp duty. So payment of stamp duty also happens at the completion stage. Now, once we're done with the completion stage, certain things have happened. Okay, certain things have happened. I've gotten all the completion documents. We've done the valuation. I've paid the stamp duty. Okay, then we go to the next stage, which is the question of registration. Registration. So that is the last stage of conveyancing. We will register. So if it is a transfer, we register the transfer instrument. So you take the transfer instrument, LR33, together with the completion documents required, and the evidence of payment of stamp duty, and the registration fee. You take the registry, they register that. Then you get your new title. Okay? If it is a lease, we will need the required lease instrument. There's a standard lease instrument duly prepared together with completion documents and evidence of payment of stamp duty and the application fee equal registered. If it is a charge, we need the charge instrument. We need the payment of stamp duty for the charge. We need other completion documents and then we register the charge. And then kila mtu aende nyumbani kwa mama yake akiwa amefurahi. That is the entire process, guys. Now, this process really confuses, guys. At the back of your mind, I want you to have it somewhere in the subconscious part of your brain. Have it somewhere, okay? Because if you have it there, it will keep coming. You remember it, okay? So due diligence, lazima tuangalie shamba imetoka wapi. We need to draft. We need to do the completion process, the preliminaries in the completion process, and then we register, okay? That is very important. Now, contract for sale of land. That is the first thing under the first thing called transfer. So transfers, we start with the contract for sale of land. Contract for sale of land, same process. Like I've said, due diligence is the first thing, the pre-contract stage, due diligence, drafting of the contract, completion, registration, which comes with the transfer. Guys, are we together? Have I moved faster? Did you hear what I said lastly? Was I fast or was I slow? This is what I said. After everything I've said right now, our next topic is contracts for sale of land. Contract for sale of land. Now, in this topic, we are discussing how do we transfer land. I've said the word sale is a pedestrian wording. It's pedestrian language. You've gone to law school 4 years. I don't know about your 4 years in campus, but I know about mine. Okay, you've gone to law school for 4 years. You've been in KSL for another 1 year. You can't afford to talk like a pedestrian. Transfer. Call it a transfer. Can everyone say transfer? So nasikia vizuri ukisema transfer. So say transfer. So we're talking about transfer of land. Transfer of an interest in land. Now, under the contract for transfer of land, contract for sale of land, there are three stages. There are various stages, like I've said. The first one is due diligence that we're going to discuss. Due diligence, what we call the pre-contract stage. So we have the pre-contract stage. So the pre-contract stage, there are things we need to do at the pre-contract stage. Number two, we go to the drafting stage. Drafting stage, which I've already explained what you need to draft. And then the third one, we will need to talk about the completion stage, what happens at the completion. And then the fourth one, we will need to talk about what happens during registration and the final bit of it, which is transfer. Now, once the registration has happened, then of course, automatically you get the transfer done. So that is the process that we will discuss. Once we're done with that, we're done with this topic, we go to the question around leases. The same thing we do for leases, and then we go to charges, and the same thing we do for charges, and then we shall fly to the rights in alieno solo, cautions, restrictions, and inhibitions, way-leaves, restricted covenants, and profits apprehended. Those ones will be our last discussion about conveyance. So it is not complicated. Now, we start officially on the question of contract for sale of land on Sunday. Like I've said, we'll not have commercial on Sunday. We'll have conveyancing on Sunday for reasons best known to myself. Don't have to worry about anything. I have you covered. So with that, we can take all the questions that you have. Okay, we can take all the questions that you have, can explain anything that is not, guys, again, let me tell you something. When you go through these units in KSL, okay, sometimes they don't make sense. And sometimes you are in some situations where you have to ask some questions that you might think are very petty questions. Now, from me to you, I'm telling you, you need to ask as many petty questions as possible, because most of the times when you ask a petty question, you will not forget about it. So don't be shy. Don't be shy. How old are you? I think you're old enough. Don't be shy. Just ask. Even if you don't know who the president of Kenya is, just ask me. I will tell you who the president is. Okay? If you don't know where KSL is, if you don't know what land is, I will tell you. Just what I'm saying is, don't sit there and say that you are shy and you can't ask a question. Ask those questions, because trust me, people are not the same. Some people will understand on the first talk, some will have to get it repeated. So do that. You know yourself. If you can't say it, drop it on the chat there. There's a chat box there. So, Wakiaga, what is your question? And then Gate.
Well, Mwalimu, I want to take you back to easements. There are times when some of these easements may cause some inconveniences of the land. Now, supposing the person having the interest on this land has accepted to give an alternative to the easements that maybe is cutting just across the land, and maybe you decide that any easements you'd want it to go to the edge of the land. Is there room for negotiation, or once that easement is done, there's nothing you can do about it?
No, there's room for negotiation. It's not a cast on stone thing. For instance, if there's a way that cuts through that somebody mute your microphone. If before I bought the land, there was a way that was passing directly across my land. Okay, if I buy the land, I can say, hey guys, I want to construct my house here. So because of that, we are going to divert this way. We are going to say this way does not go straight. It will go along the edges of my land until where you're going to. So I will create that another easement. I will create the way here. The fact is, there should be way. You can't deny way. If you deny way, you give us the alternative. Because what I'm concerned with as remember we have the types of tenement. We have the servient tenement and the dominant tenements. Okay. Now, as the dominant tenement, what I'm concerned about is the right of way. So if I pass through your land to get to my house, you cannot block it. Give me an alternative and tell me, hey, instead of passing directly horizontally across my land, use this one, go this way, turn right, turn left, and then get to your house. Okay, so yes, you can. It's not like it must be like that. But also another thing you need to understand is that when you're buying land, when you're doing your due diligence, you need to also confirm the register and know which easement, because these easements are usually noted in the register, or some of them are. You can go and see for yourself. So note down the registers, the easements that are existing, so that you ask yourself, am I happy with people passing through my land, or is there something I can do? Okay.
Thank you.
All right. Get to Oshe. Somebody mute your microphone. Someone, I don't know who that person is. Let me see.
Well, Mr. Jackson, beside the year of registration, like, is there another way of differentiating LRA and RLA?
There's no other way. It's like I've told you right now, RLAs were issued before 2012. The naming is the same, due diligence is the same. The only thing that differentiates them is the nature. How do you know the nature? The year it was issued. If it was issued before 2012, like for instance, I've told you, we have Nairobi Block 1. Nairobi Block 1. Okay, so Getu is the proprietor of Nairobi Block 1. Okay. Now, this title was issued to Getu in 205. Okay, in 205. So what are the things about this title? It is freehold. It was issued in 205. Okay. We do due diligence at the district registry. Okay. So that is that. Then we have another Nairobi block 6, belonging to Agnes Muthoni, belonging to Agnes Muthoni. Now ask yourself, this one also, the naming is the same. The naming is the same. Okay, where do we do the due diligence? We do due diligence still at the district registry. Okay, at the district registry. Someone is speaking. At the district registry. Are you together? Now, what will differentiate the one Getu has and the one Agnes has? What is the difference? The difference is this. Now, for this one that was issued in 205, it is a freehold because it was issued in 205 before 2012. This one is issued in 2013. Okay. Now, if it is issued after 2012, there are two chances. Let's start the other way around. If it is issued before 2012, there's only one option. It is a freehold. There's no discussion about it. It is a freehold. But if it is issued after 2012, there are two possibilities. The possibilities are it can either be a freehold or it can either be a lease. So how will I know it is a freehold or it is a lease? I read further on the title. So I will go down and say this one was issued in 2013, and then the title will tell me it is a lease for 99 years. Okay, so what you're saying, what has been eliminated is the automatic assumption. Before 2012, it is automatically a freehold. That is, if you see a Nairobi block before 2012, it is automatically a freehold. But if you see a Nairobi block after 2012, you need to stop and say, this one can either be a freehold or a leasehold. How will you know it is a freehold or a leasehold? The examiner will tell you, or the title will tell you. You keep reading and you're going to find something that is going to tell you it is a leasehold, which is number one, maybe rent is this much. You only pay rent on leases. Rent is this much, or the title is a lease for 99 years or for 50 years or that one. Okay, or Agnes is having a leasehold interest. The question clearly says it, or the title clearly says it. So what I'm saying is, after 2012, you need to read more and get the exact nature of the title. Before 2012, it's obvious it is a freehold. Tuko sawa?
Yeah, tuko sawa. Thank you.
All right. Is there anyone? Let me pamper you and massage you. Is there anyone that has another question that I haven't answered that is confusing you? Okay. Now, if you allow me, I will explain. I'll just explain something small about sectional titles, sectional property titles, and then we can adjourn, or you can leave at your own pleasure because we're done with the class. I just wanted to explain the history of SPA titles, sectional property titles, Sectional Properties Act titles. Somebody's really looking for trouble. So, guys, first, should I talk about history of SPA titles, or do I just leave it?
Please do.
All right, somebody is saying some things. I don't know what's wrong with them. Can you mute those things? They're really not good to my ears. Let me look for you. See who is this person. Mute your microphone, guys. Allah. All right, so like I've said, I've already covered what I wanted to cover right now. So if you want to leave, that's fine. Now, SPA, what is an SPA? Sectional Properties Act. This thing has gone through what we call it has gone through two sets of histories. Okay, so let's talk about it and why do we have it? Okay, most of the time I told you guys the most important thing you need to do is ask yourself, why do we have what we have? Okay, why do we have what we have? It's very, very important to ask yourself that. Why do we have what we have? Very, very important. So SPA came from 1987. The title that came in 1987. But before 1987, what used to happen? Now let's go back to the history of Nairobi. So you know Nairobi, how Nairobi used to be. You know how Nairobi used to be. Okay, when Kenya we just maybe 5 million people or 4 million people. So there were a lot of spaces within the commercial areas. There were a lot of spaces. I mean, everyone could afford to get their own compounds in Nairobi because not so many people were living in Nairobi. So you could get your own house in Nairobi. In fact, all the Maasais used to stay in Nairobi. I don't know why they left Nairobi. Okay, so you could get your own space in Nairobi. Okay, now as the population kept growing, it became impossible for everyone to have a space of their own. Okay, to have a space of their own. Now, what did the government do? What did the government do to address the fact that people can no longer have a space of their own because land is becoming too small, we are getting too big. So what did the government do? The government introduced the concept of having apartments were introduced. How? That, hey, instead of if you have your 100 by 80 by 100 acres of land, you know what? You can construct an apartment. Some people can stay on the ground floor. Some can stay on the first floor. Some will stay on the third floor. Okay, so that was the solution to the fact that not all of us could have their individual houses in places like Nairobi because that land was not enough to accommodate everyone. So the solution was, let us introduce apartments. Okay, now the process of introducing apartments came with a challenge. What is the challenge? The challenge was that even as we build the apartment, and I'm going to stay in the first floor or the second floor, maybe room number 10, the question therefore would be, I want a title of my own. Okay, my uncle who is staying at this place is having their own compound and they have their own title. Okay, my friend who is staying at this place is having their own compound and they have their own title. Okay, I also want to own my title. I want to own my house. Okay, I want to buy my house. So I could buy my apartment, but now if I buy the apartment, how do I get the title to the apartment? Because at the moment we only have 80 by 100 and only one person has the title. The land is 80 by 100 and the owner of the land or the owner of the apartment is the one having the title. So how do we get the title? All of us that are staying in this apartment, how do we, cut that title into pieces so that each of us, whoever is staying in the first floor, the second or the third floor, also has something to show for the house that they're staying in. So because of that, we introduced what we call the Sectional Properties Act of 1987. What did that act provide? That act now said, hey guys, something new has been introduced. In fact, you can build your apartments, you can build the apartments, and then you divide it into units, and then you can sell these individual units, and then any person that buys the individual units, you can give them a title. Okay, and these titles, we are giving them a special name. We are calling them sectional titles. So that I go to a place, I like the apartment, I get a house in that apartment, and then I get the title. That was how we addressed the question of not being able to own a house after construction of the apartment. The 1987 Act called the Sectional Properties Act. Now that act came with what we call the sectional titles. What was the main feature of sectional properties house ownership? The main feature was you build a house as big as you want, you divide it into units, and then these individual units, you can sell them to someone. Okay, now, what was the challenge with that entire process? What was the challenge with that entire process? The challenge was this. The new act came with the restrictions. Okay, what was the restriction? The restriction was this. It said that, hey, mwenye shamba, remember, what was the shamba? The shamba was 80 by 100 and the title was 1. So it said, hey, if this land is yours, the land upon which the apartment is sitting, if this land is yours, if it is a freehold, you can have unlimited sectional titles because it is a freehold, okay? But if it is a leasehold, kumbuka, this land is not yours. So at some point, it will go back to the owner, who is the government. So for guys that have leases, you can only create a sectional property on that lease, on those leases, if the remaining period on the lease is 45 years and above. What am I saying? If I had a lease, if I had, let's say from the freehold, if I had a freehold property, the government will tell me, you go ahead, create your apartments and sell them. You have a freehold. Hakuna mtu anakusumbua, you're the boss. But if I had a leasehold, the government will ask me, how long is remaining on your leases? I will say, my lease has 45 years. And then they will tell me, fine, go ahead and construct your sectional, your property and transform them to sectional units. Another person will come and say, hey, I have a lease of 30 years. The government will tell you, no, 30 years, you cannot get admission to sectional properties. Are you together? So that was the challenge. So you build an apartment, you divide them into units, you apply to the government to register those units. Once those units are registered, this mother title is closed. Or in other words, the moment I have a piece of land, I will have a bare piece of land somewhere in Rongai. It is just a bare piece of land. I will construct my apartment on it. The moment I construct my apartments on it, I will apply to the register of lands to register the units. So for the registrar to register the units, the registrar will tell me, hey, give me the title. So I will give the registrar my title. Okay, the registrar will close the title, and then the registrar will now create new titles for the units. So in short, my title for the 80 by 100 has given birth to the number of units or the new titles as per the number of units that I have. So if my apartment has 50 doors, the registrar will create new 50 sectional titles that I will be able to give. So if you come and you're staying in house number 1, I will give you, you pay me, and then I give you the sectional title. And that is how we got to the sectional titles. Okay. Now for people that who could not get the 45 years because of leases, they went to the RTA system. That was the sublease system. I will explain that later. But up to there, I just wanted you to understand, where did this concept of sectional properties come from? Okay, it came from the need to create more space. How could we create more space? Build an apartment going up, divide them into floors, and you can find that even though 10 people, 100 people cannot exist on an 80 by 100 plot, if you build an apartment, you can even have 50,000 people on that apartment. Okay, that was the challenge, and that was the solution, and that is why we came with the SPA, the title. So those titles were there. So when the new act came in 2020, the government said no. Instead of calling them sectional titles, we baptize them. We now tell them, hey, it is still the same thing, but we are now calling them certificate of leases and certificate of titles, if they're a lease or if they're a freehold. That is the short and the long history of sectional property and how they came to be in our legal systems. We'll have a whole discussion about sectional properties. Don't worry. If you are hearing it for the first time, don't worry. It is just a synopsis of what we used to have and what we have and why we have it. That marks the end of this call. Have yourself a wonderful Thursday. Don't drink and drive. The recording has been stopped. I will share the recording when I do. And